first case to come before the court is State versus Thomas. Both sides will have 15 minutes to present their argument. You don't have both sides, do you? That's right. You will have 15 minutes to present your argument. And we won't even force you to rebut yourself. So it's your day. It's your day.
Thank you very much, Your Honor. May it please the court, good morning. I'm John Parker. I do represent Mr. Randy Thomas. Appreciate the opportunity to address the court on this important case. This is a case, as the court is familiar, is an aggravated murder case in which my client was charged with aggravated murder, convicted of straight murder, and argued self-defense at trial, which was rejected by the trial court. And I do note that this court affirmed his conviction yesterday on direct appeal in a 2-to-1 decision. This is the post-conviction aspect of the case under 2953-21. And the main arguments here concern ineffective assistance of trial counsel because they failed to investigate and present evidence of Mr. Thomas's state of mind through records and witnesses that were readily available, but they failed to obtain, procure, and present. And as the court is very much aware, in the state of Ohio, self-defense has a subjective component to it.
Let me ask you, counsel, because since there's only 15 minutes, and I know a couple of us were on the direct appeal.
Yes.
I'm just trying to think, I guess we all were on the direct appeal. But anyway, the point is, I'm concerned, and I'd like to hear from you as to what impact that direct appeal, since we did release it yesterday, what impact our ruling on the direct appeal may have in regard to this post-conviction relief.
Well, they're two completely separate matters with completely different standards, evidence. This is under 2953-21. The direct appeal, of course, is limited to the record at the trial court during the appeal itself. On the other hand, this post-conviction is limited to things outside the record, which we present.
Sure, but one of the arguments, I guess what I'm getting at, and I'll just get right to it, is one of the arguments, or several of the arguments the state makes is, well, this is a matter for direct appeal, you know, that type of thing. So, and then with our direct appeal, we're saying a lot of stuff is not in front of us.
And it's a conundrum. It's a conundrum. The ineffective assistance claims that we present in this post-conviction could only have been presented through post-conviction. And I say that based upon the exhibits we attached to the post-conviction petition. Let me get right to the point. My client had a very low IQ, has a very low IQ. The bottom 9% of the population. That goes to the subjective element of self-defense. That could not have been raised in direct appeal because the lawyers didn't present anything about that, even though it was readily available as we presented in this case in post-conviction. And what I'm talking about specifically are the Akron City School records, which show that the client has a very, very, very low IQ. And through the supplemental authority I filed a couple of weeks ago, the Williams versus Mitchell case out of the Sixth Circuit, I would point the court's attention to footnote 4 on page 17, and the important point there is that intellectual capabilities remain stable throughout life. So this low IQ that we have testing for through the city school systems, the Akron City school systems many years ago, shows that my client had a very low IQ. That's part of the subjective test. That's part of the subjective self-defense. The jury had a right to know his intellectual capabilities and how he would perceive the threat from the victim who pulled a gun on him.
But the state's response to that is, okay, that's all fine and dandy. Of course, they don't agree that he even had the right to present those or that it's relevant to the defense of self-defense. But they also are saying, well, so what? Because he actually testified. So the jury could assess his demeanor, his credibility, his intellectual functioning in regard to his testimony.
But you can't tell someone's IQ or intellectual functioning just by talking to them.
You can't tell their IQ necessarily, but you can get an idea maybe it might be lower or higher.
Well, but he was presented as kind of an average person. And the state even argued in closing arguments that if he was slow or something like that, then they could have presented documentation, and they didn't. Well, they didn't because they didn't look. And it was readily available, the defense, that is.
I have a question for you, too. Another question. In regard to his jury instructions, because obviously if you read the decision, you know that that was a big bone of contention in regard to my evaluation Was there any evidence that was presented to the trial court in the post-conviction relief as to whether or not those jury instructions were answered, whether the attorneys were present when the judge gave the written answers back to the jurors?
Well, what we have is an affidavit from the client who says he wasn't present.
Right, I understand
He didn't
that.
waive. The attorneys wouldn't respond to my phone calls, wouldn't respond to my letters. The judge would not give me an evidentiary hearing. He would not give me discovery. So I couldn't present anything in post-conviction from the lawyers themselves. I think it was incumbent upon the trial judge to make that finding or not, which unfortunately he didn't in the post-conviction, which I'm...
Did you allege that the attorneys weren't present when the questions were answered to the jurors?
I believe I did, Your Honor.
I understand you may not have anything to back it up, but that was an allegation in the post-conviction.
Absolutely, and certainly the judge was there and would know. And, it's a critical part of the case, and all we can do is present what we can. And if we don't get a hearing, and if we don't get discovery, and the lawyers don't cooperate in the investigation, there's really nothing more we can do. And that's why, the judge really needed to have a hearing in this case. The documentation is abundantly clear. They're Akron City School records. There are records from the Greenleaf Family Center. There are records from the Summit County Jail showing that the lawyers never appeared at the jail and to visit the client. Now, the client did say that one attorney did come to see him in the weekend right before the trial, but the other attorney never came to see him in the Summit County Jail. So how could they prepare? And coming the weekend before is not sufficient to get the records that are needed that I'm talking about.
Well, I don't remember right now, but one of the allegations in the direct appeal, I know, was the fact that the attorney had raised the issue of self-defense in the opening statement.
That's correct, and that's the attorney who never went to see him in the county jail, according to the jail's own records, which we provided in post-conviction, and which the client averred to in his affidavit. So we have corroboration there, and that's a huge problem. I don't think the records can fairly be disputed. They're Akron City Public School records. There's the Greenleaf family records. There's an email from the Summit County jail personnel who's responsible for the visitation records. There's Social Security disability records. All the records are there. If there's any question as to their authenticity or accuracy, the state did not raise that. And if the judge thought there was any question about authenticity, then it was his responsibility to hold a hearing as requested to make that factual determination.
I guess of concern to me, or at least not to the whole court, and I'm sure it is to the whole court, though, is how many times do we have to say an attorney has to visit somebody in order to get adequate representation?
Well, I don't think the court can set a bright line rule, but I certainly think when someone's facing an aggravated murder charge, when one lawyer never visits, and the other lawyer primarily visits the weekend before the trial, the Friday, Saturday, Sunday before a Monday trial, that's not sufficient when these records are available and they are relevant to the client's state of mind, the defense presented, the subjective component of the defense presented. And I'd ask the court to remember that there was a flight instruction given here because the client left the scene of the crime and eventually left the state of Ohio. And so there was a flight instruction, and that's a terrible instruction for the defense because it says, unless this flight is otherwise explained, then it's indicia of guilt. Well, part of the explanation that could have been given and should have been given was, this gentleman, my client, is a very low IQ. He's not a very smart guy. Perhaps that explains his subsequent actions after acting in self-defense. He's the bottom 9% of the population, borderline, I would say, mental retardation or intellectual disability. We're not claiming he's intellectually disabled, but he's borderline. And he's been that way from school records through testing we know. We know through testing at a very young age, more than once. And we also know through the Greenleaf Family Center records, where he went for some counseling, that he was not homicidal, which I find very curious, because that shows that corroborates. That's a piece of evidence corroborating that he was acting in self-defense. He didn't go there with the idea of killing somebody. He agreed to a fist fight when the other guy produced a gun. And he acted in self-defense in disarming that man And when the man kept coming at him, even though he had the gun, he had to shoot him to protect himself.
And forgive me again, because being on both cases.
Sure.
Did you raise ineffective assistance of counsel in regard to the attorneys not objecting to the jury instructions in regard to self-defense and with fault in particular?
Yeah, there was
obviously a big thing in our.
That is a big, yes, Your Honor, that is a big issue, and I did raise it under both plain error and ineffective, the problems with the jury instructions. And the jury clearly, through the note that they sent to the judge, clearly had a problem. He said, what if the defendant was 10% at fault in causing the fist fight? Well, you know, if they knew about his intellectual limits, his low IQ, that may help them answer those questions as to whether he was at fault in causing.
Well, and I understand that, but I guess what I was meaning was that nobody requested or submitted a jury instruction on what constitutes fault.
No, they didn't, and that's why we raised it as an unconstitutionally vague instruction. We raised that under both plain error and ineffective assistance of counsel. Unfortunately, in the 2-to-1 decision, the majority rejected that on direct appeal, but I think this illuminates the issue, because I think it certainly is something the jury should have known about under the subjective component of self-defense about my client's limited intellectual abilities and how that would impact on whether he was at fault under the instruction given. And I would point the court towards evidence rule 901 concerning the authenticity of the documents. I don't think there's any question that they were properly authenticated. But I would also point the court in the supplemental authority, the Sixth Circuit case, Williams versus Mitchell, decided just on July 7th, pages 20 to 23. This was a Trumbull County case. It was a capital case, but nonetheless, it talks about how you can't have a rule of evidence or any other type of rule that precludes someone from presenting a defense. That becomes unconstitutional at that point. And clearly, these records are properly authenticated. They're relevant to the state of mind, the affirmative defense, which the client had the burden under Ohio law of proving. These records were readily available. They could have had Dr. Webb from juvenile court. There was also a report from juvenile court written by Dr. Webb concerning my client's state of mind, concerning his background. All they had to do was call Dr. Webb as a witness, and he could have testified about his own report. Or they could have asked under 29-29024 for expert assistance because the client was indigent. And in every aggravated murder case, one is entitled to expert assistance as long as you can make a showing. And certainly there's a showing here, given the records that were readily available but not obtained.
Counsel, you mentioned that, is it Trumbull County you said?
Yes.
And it's July 7th?
Yes, it was submitted
That's okay.
the next day, July 8th, or 9th, it was filed in this court as supplemental
I was
authority.
going to say, I want to make sure you did do that.
Yes, I did file a copy of it. It's Williams versus Mitchell, 7/7/2015, the Sixth Circuit. It was an Ohio case out of Trumbull County where the issue was whether the person's mentally retarded or not and could face the death penalty. And the Sixth Circuit reversed the Ohio courts and said, you've got to have a hearing, you've got to look at these records. And I'd encourage the court to look at that, especially footnote 4, which talks about the stability of intellectual ability. That once, you know, it is assumed under the law that once you have an IQ or once you have an intellectual ability, that is stable through life. And that's important here because our IQ records are from a young age, from elementary school. And then also, as I said, through pages 20 and 23, that you can't exclude under some rule, improperly exclude evidence, such as the reports we submitted in this case. They're absolutely properly authenticated. But Dr. Webb could have testified. The people at Greenleaf Family Centers could have testified concerning his state of mind that he was not homicidal. I mean, how critical is that? In an aggravated murder case where you're claiming self-defense and the state is arguing otherwise.
Well, if you had an evidentiary hearing, what would that accomplish that you couldn't accomplish here?
Well, I suppose, you know, the trial judge, the fundamental problem is the trial judge here on the post-conviction made credibility determinations without taking evidence, without any evidence contrary to what we presented. The state didn't present anything to the contrary. They didn't say these records weren't authentic or anything. They just said they don't matter, they don't apply, they're not relevant. Well, that's clearly not the case when there is that subjective component to self-defense.
I suppose too, you could subpoena the attorneys.
Absolutely. Could subpoena the attorneys to find out some of the questions that the court has posed. We could bring in the witnesses behind the records so that the judge could ask any questions he wanted, or the state could ask any questions they wanted concerning the records. It would just have a better factual foundation to make any decision here, is to have a hearing. That's what trial courts do. They have hearings. They make factual determinations after listening to both sides.
And counsel, I hate to tell you, but your time is up.
All right. Well, I appreciate the court's attention. I think you're very much aware of our position in this matter. We asked for a remand for a hearing or straight out grant of relief.
The court will take the matter under advisement. A written opinion will be sent to you as well as to the state, as well as you can look